People versus Amanda Jane Christensen. Ms. Christensen is here for sentencing. Prosecution and defense was the pre-sentence investigation report timely made available to you.
Well, Judge.
Mr. Wahlberg?
Yes, Your Honor, sorry.
Right. And Mr. Prysock, have you the opportunity to read the report and discuss it with Ms. Christensen?
I have, Judge.
Do you have any additions, corrections, or challenges?
Judge, I'm looking at the sentencing guidelines that was scored by the probation department on the controlled substance offense.
Anything you said?
Can you talk a little louder, Mr. Prysock?
Actually, on all.
All right, so controls, we'll start with the controlled substance one first.
Yeah, and then, well, actually on all three, Judge.
Okay.
My challenge is on OV12. They have scored at 25 on one of them, the controlled substance. They have it scored at 25 on one of the resisting, and then they have it scored at 10 on one of the other resistings. And I believe it should be scored 10 on all three because she was found not guilty of the domestic violence charge. So instead of 3 assault crimes against person, it should be 2, which would put it at 10 instead of 25, which brings our guidelines down to 19 to 38 on the possession charge. And brings it down on probably all the others too.
All right, so Mr. Wahlberg, the challenges to offense variable 12, the argument is that acquitted conduct should not be scored under that variable.
Yeah, interesting issue, Your Honor. Mr. President, tipped me off to this yesterday when we were going through this. I don't think that's how OV12 works. The court may correct me. I think OV12 scores, I guess in order to score, it's a criminal act that has not and will not result in a separate conviction. So as a prosecutor, she was acquitted, I think, of DV3 and 2 additional counts of RNO, Michigan State troopers. Hence, she was acquitted. Those did not result in a separate conviction. I believe the court could make a finding that those things still existed. I'm not saying the court's going to do that. I went through all the case law just because I was getting curious. Couldn't find anything to say the court could not score those when someone was acquitted. However, I guess the caveat of the court, just because I thought this was interesting, she is in a worse spot being acquitted of those charges. If she was convicted of all 3 of those, they're just subsequent or concurrent. She's already capped out her subsequent or concurrent points, and her guidelines actually come in lower. Do I think the court can score those? Yes. I'm assuming that was the rationale probation parole used in scoring those points. Is it fair? I'll leave it up to the court. But certainly I think the court could make that finding of scoring that conduct.
All right, so I looked at the issue just quickly this morning. I'm sure there's published a caseload or cases for this proposition, but I found quickly People versus Brooks, which is a 2009 Mishap Lexus 2520, which essentially says that the court can score acquitted conduct if I find by a preponderance of the evidence that the conduct occurred. So that does give the court the ability to score acquitted conduct. I just have to make that particular finding. So on that offense variable, the court is going to find that there was, by a preponderance of the evidence, domestic violence third committed. And the court recalls the testimony that Ms. Christensen was having a shouting match, I guess is the best way to describe it, with her son, at which time she flicked her cigarette at him, causing him to have to take evasive measures. So the court does find that by preponderance of the evidence that crime occurred. The court is not going to score other resisting, obstructing offenses. The court directed verdict on one count of that. And I stated the reasons for the directed verdict of acquittal on the record there, but essentially it was unclear whether Ms. Christensen was resisting or was avoiding any or disobeying any commands that were given by those two particular officers. So the court is going to just find that there was one contemporaneous felonious criminal act and score 5 points for offense variable number 12. Mr. Prysock, did you have any other challenges to the offense variables before I start making calculations here?
No, Judge, I do not.
Okay. So the possession of methamphetamine charge with offense variable 12 being scored at 5 points, that would bring the total offense variable down to 30. For the resisting, obstructing, causing, requiring medical attention, it was scored at 10 points. So we're only going down 5 points there. So that would give you offense variable total at 40. And then for the resisting, obstructing the police officer, it goes down 20. So that would be at 40 points there. Mr. Walburn, before I go to the grids, do you have any challenges to the scoring of the advisory guidelines?
I don't, Your Honor. I looked at that issue. I got 10 to 23 on the meth charge. I hope that's what the court's got now.
I haven't got there yet. Well, then we have the issue of the habitual offender. Third,
Correct.
the probation department didn't score it on the habitual offender third, but it was charged on original information, and there was another information filed after the jury verdict. So let's look at the possession of methamphetamine charge. That's a class D. Prior record variable is a D. With 30 points on the offense variable, that would be 3. With the habitual offender third, that would be 10 to 34.
That's what I have here on them.
For the resisting officer requiring medical attention, that's a class F. It would still be prior record variable D with 40 offense variable points. That would be 10 to 34. And then for the last resisting obstructing, the class G, D3 would be 2 to 25. So, Mr. Prysock, any other additions, corrections, or challenges to the report?
No, Judge.
Anything that you'd like to say on her behalf?
Well, long history with the case. The court's been with it actually longer than I have, but it's been quite a while since we got to this point. And I mean, if the court recalls from the jury trial, I believe the possession charge was based on some residue liquid that was found in some syringes. So it wasn't like she had a large quantity of methamphetamine. Court watched the video. You all know what happened with the resisting and obstructing. The jury found her not guilty of the domestic violence. So she's been in jail for more than a year now. I note that the original offer by the prosecutor was, I think, a 10-month cap. She entered her plea, and we came in to try to plead a couple times, and it was not fruitful. It didn't happen. So she was willing to enter a plea, but I think the hang-up was more about the prior offenses and her confusion in that regard than her not wanting to actually enter her plea. So we're asking the court to take those factors into consideration with the new sentencing guidelines. She does guideline out to potential county jail time. It's been, more than a year that she spent. So we're asking the court to give her credit for the time that she served in jail, judge, instead of a sentence to the Michigan Department of Corrections.
All right, Ms. Christensen, have you had the opportunity to read the report and discuss it with Mr. Kreishag?
Yes, sir.
Do you have any additions, corrections, or challenges?
No, sir.
Anything that you want to say on your own behalf?
Just that I'm extremely sorry that I've come to this point in my life where I'm before the court, and I would like a chance to be a productive citizen still. Very much so. I'm anxious to get back into the world and try to do better things with myself.
Okay. And Mr. Walburn, any additions, corrections, or challenges?
Nothing we haven't already talked about, Your Honor.
Anything that you want the court to consider?
Nothing additional.
All right, so the court recognizes that we're dealing with 5 different offenses here. We've got 3 that are felonies. As we went through, the court recognizes that the advisory guidelines would suggest a sentence for count 1, possession of methamphetamine, between 10 and 34 months. For count 2, resisting obstructing police officer requiring medical attention, 10 to 34 months. Count 3, resisting obstructing police officer, 2 to 25. All right, so the court's going to exercise my discretion and sentence this defendant as a habitual offender. Third, the record does reflect that she does have 2 prior attempted felonies, and that the guidelines that I just cited reflect that habitual offender. Third, the court's going to exercise my discretion, sentence consistent with the advisory guidelines. To be the sentence of the court that this defendant served 24 months on the minimum to the maximum of 20 years for count 1, 24 months on the minimum to a maximum of 8 years for count 2, and 24 months to 4 years for count 3. The court's going to order that count 2 and count 3 be served concurrent. The court does have the option to sentence consecutive for those 2, but the court's going to exercise my discretion, sentence concurrent for those 2 offenses. So all 3 felonies would run concurrent with each other. I'll give her credit for the 397 days that she served so far. For count 4, the sentence of the court would be 93 days in jail, 93 days credit. For count 6, 90 days jail, 90 days credit. There's a $68 state cost assessment for counts 1, 2, and 3. There's a $130 Crime Victims' Rights Fund fee. There's a $50 state cost assessments for count 4 and count 5. There's a $60 DNA fee that's going to be imposed as well. So, Ms. Christensen, the record reflects that you have not been successful previously on probation. That's one of the reasons the court is not considering a county jail sentence, that you have not been successful in probation before. You also have prior assault convictions and prior resisting obstructing a police officer convictions. And given your combative nature with police, when you have encounters with them, the court believes that a prison sentence is appropriate. The court sent it to you basically at the midpoint of the 10 to 34 months. I understand that the methamphetamine was just residue. That's why the court did not impose a higher sentence on that count. But whatever started going on in your life about 5 years ago, I hope you get a handle on it, because your criminal history just started 5 years ago, and you did pile up 8 misdemeanors since then. I don't know. I'm guessing it was a drug issue, but I don't know that about you. But something went wrong 5 years ago. So hopefully, as you're sitting and thinking about it, you figured out what that is and have a plan to address it so you don't come back again. The problem is if you come back again, now you've got 3 more felonies on your record, and you've got a couple more misdemeanors. Well, those aren't going to score, but the felonies will. So if you come back again, it's going to be another prison sentence. Nobody wants that for you. So the court directed these financial assessments would be collected through the inmate account and parole process. You do have the right to appeal your convictions and sentence. If you could not afford an attorney, the court would appoint an attorney to represent you at public expense. Request for lawyer must be filed with the court within 32 days.
I'll us in the comments. Was the judge fair or too strict after the acquittal? And don't forget to subscribe for more real courtroom stories.